Have you worked out something in the way of a plea on her case?
Your Honor, my name is Michael Pennell on behalf of Mary DeRossett. We do have a global plea agreement ready to go, signed by both the state and the defense and Ms. DeRossett. However, it is a cap of a year and otherwise an open plea to you, Your Honor.
All right, if you'll go ahead and announce the terms of the plea case by case.
Yes, Your Honor. In case number 2014 MM 50731, Ms. DeRossett is charged with use of possession of drug paraphernalia, petty theft, and there was an amended information filed in September giving a false name or identification. Case number 2, 2015 MM 35073 is solicitation of prostitution, lewdness. Count 2 is driving while license suspended. And finally, in case number 2015 MM 39028, it's count 1 solicitation, count 2 resisting without violence, Your Honor.
All right, and what are the terms of the negotiated plea?
Your Honor, this is a plea of no contest. I think it's important to state for the record that this is what Ms. DeRossett believes is in her best interest. Ms. DeRossett, the first case that was before you, Judge Friedland, was in November of 2014, so quite removed from the incidents that we're here for today. Ms. DeRossett was out on bond on that. The second case was from July, and she had a bond on that one too. But as this newer case happened, her bond was revoked on the first one, and she was given no bond on this most recent one.
All right.
So I just wanted to state for the record that this is something that we are pleading to it because of a best interest issue and not because of an admission of anything.
All right.
With that said, the only terms that are set in stone is the state is agreeing to a cap of 1 year. And other than that, they are seeking the costs associated. So it would be the cost of prosecution, cost of investigation for all 3 cases. That would be, and I'll read it for the clerk.
Okay.
In case number 2014 MM 50731, it would be $291.39 to Titusville Police Department. In the second case, 2015 MM 35073, it's $684 to Brevard County Sheriff's Office. And finally, in 2015 MM 39028, it's $354 to Brevard County Sheriff's Office. Now, there are no other negotiated terms other than what will be presented to you, Your Honor, now.
All right. So she's pleading no contest to all charges?
Yes, sir.
All right.
Oh, Your Honor, I'm sorry. Importantly, count 3 on the first case has, in contemplation of the negotiated plea, the state has agreed to drop count 3, giving a false name or identification. They are going to null pros that count.
Right.
I'd also like to point out that that's something the defense feels very strongly about, that they could have been won at trial. Ms. DeRossett has 2 names. Her given name is Ms. DeRossett. Her married name is Ms. Ellis. That was the basis for the giving false name. Okay. Nonetheless, the state has agreed to drop that. So no contest to the other remaining counts, Your Honor.
All right. And is the state in agreement?
Yes, Your Honor.
And this is a 1-year jail cap for all charges combined. So anything would be concurrent.
Yes, sir.
Up to a maximum of 1 year.
Yes, Your Honor.
That's correct, Your Honor.
Okay. All right. Or consecutive up to a maximum of 1 year.
It doesn't have to be jail, Your Honor.
Right.
It could be probation.
Could be probation.
If it's probation, it can exceed.
But the jail has a cap on it.
Right.
Okay. All right. All right. Ms. DeRossett, would you come on up and step up to the podium? And would you raise your right hand as best you can? Do you swear or affirm testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? Are you per hand up? So did you hear the terms of the plea as just announced? All right. And is this what you want to do? Has anyone forced you to enter this plea? Has anyone promised you anything other than what was just announced? Are you satisfied with the advice of your attorney? You understand by entering this plea, you are giving up your right to have a trial. And I don't know if you were here earlier, but basically if you were to go to trial, you'd be presumed innocent. The state would have to prove that you're guilty beyond all reasonable doubt. You understand that? At a trial, you'd have the right to a trial by jury. The jury would have to unanimously find you guilty before you could be convicted. You understand that? You'd have the right to remain silent at trial. You cannot be forced to testify, but you could if you wanted to. You understand? You already have an attorney to represent you at trial. If you were found guilty after trial, you'd have the right to appeal your conviction, and if you cannot afford an attorney to handle the appeal, I could appoint one for that. You understand?
Yes.
You'd have the right to call witnesses on your own behalf at trial and subpoena them to make sure they appear in court, and you'd have the right to cross-examine any witnesses against you. You understand?
Yes.
So by entering this plea here today, do you understand you're giving up all those rights you would have had by going to trial?
Yes.
And is this what you want to do? All right. Are you under the influence of any drugs, alcohol, or medication?
No.
Are you a U.S. citizen?
Yes.
All right. Do you have any questions at all about this plea before I accept it?
No, sir.
All right. And is there a stipulation as factual basis for the plea?
Your Honor, for the purposes of the plea, with the exception of, again, no contest, I'd like to address the resisting, if you would like to hear that now.
All right. So if you're not going to enter a stipulation, I can have the state lay a factual basis then.
Thank you, Your Honor.
All right. Would the state go ahead and provide a factual basis for the pleas to, I guess, all of these charges except the false name charge?
I will stipulate to all, but I would prefer a factual basis on just the resisting, Your Honor.
Oh, I see. I see. Okay. So he's stipulating to a factual basis on for all of the pleas except the resisting. So if the state will just lay a factual basis
Yes,
for that.
John Topper for the state of Florida, Your Honor. Also, just so we can be clear, before sentencing, the state would also like to present what we believe is aggravating factors.
I understand.
In all the cases.
I understand.
I just want to make sure that that's on the record.
Right. No problem.
As far as a factual basis for the resisting, on August 20th, 2015, in Brevard County, Miss Mary DeRossett was being lawfully arrested for prostitution, and during that arrest, officers were attempting to take custody of Miss DeRossett during the arrest, and we actively resisted them without violence.
All right. I'll find that there's factual basis for the plea in all of these cases. I'll find that there is that the plea is being entered into freely and voluntarily with knowledge of the consequences and after advice of competent counsel with which you're satisfied, and I'll accept your pleas. The state want to go first and present any aggravating factors?
Yes, Your Honor. May I?
Yes. Yes. Right, and you can either have a seat over here at council table, Mr. Rossett, along with your attorney. All right, you may proceed.
May it please the court?
Yes.
Counsel. As Florida legislator has codified, the primary purpose of sentencing is to punish the offender. On November 25th, 2014, Miss Mary DeRossett was arrested in Titusville by Titusville Police Department for retail theft and possession of drug paraphernalia. This was at Walmart, and she was found with certain merchandise, I believe hair products, the total value being under $100. Also found on her possession during arrest was a syringe and spoon that field tested, at least the spoon field tested positive for opiates. I think it's also important for the court to be aware that on her person, that was in property after arrest, was found over $1,000 in cash. On July 20th, 2015, Ms. DeRossett being out on bond, released on surety bond, which had the statutory condition under statute Chapter 903.0471A, as a condition of release by surety bond, the defendant shall refrain from criminal activity of any kind. Ms. DeRossett was arrested by Agent Jason Roberts in Brevard County Sheriff's Office for the charge of prostitution. This was the Brevard County Sheriff's Office responded to a back page ad put up by Ms. DeRossett. There was a transaction made over text message, and Brevard County Sheriff's Office set up a sting at the CVS. When Ms. DeRossett was found, she was driving a vehicle, which was later found out that her license had been revoked in Florida. Further, Ms. Agent Roberts would testify to the fact that he had face-to-face interaction. He was the arresting officer and went through the whole booking procedure with Ms. DeRossett that on July 20th. On August 20th, 2015, Brevard County Sheriff's Office did a similar sting operation on a back page ad by Ms. DeRossett, and the transaction was agreed upon over text message again. And at this point, Ms. DeRossett had set the place for meeting, this time at her residence. When Brevard County Sheriff's Office arrived, they staged and set up that an undercover officer, Agent Steve, would approach the residence, make contact with Ms. DeRossett, and make the arrest with Agent Roberts and Agent Casey Smith close for backup. Agent Roberts would testify to the fact that there was lighting from a street post towards the house. The porch light was on, and also a vehicle in the driveway had its parking lights on. Upon approach to the front door, Agent Steed knocked on the door, and Ms. DeRossett answered the door. Agent Steed was invited inside, immediately pulled out a badge from under his undercover clothing, and identified himself as a Brevard County Sheriff's Office as a deputy. And he grabbed Ms. DeRossett's arm, made contact for the arrest. She began pulling and screaming. This is when immediately Agent Roberts and Agent Smith approached to assist. Agent Roberts grabbed onto Ms. DeRossett's arm to assist in the arrest, and Agent Roberts would testify that Ms. DeRossett was able to make contact with it, make visual eye contact with him, and see his face, then continue to resist after that. The state would argue that she was able to recognize in that time frame due to her previous encounter with Agent Roberts. The state would point out that Ms. DeRossett has a prior history of obstructing official business and a conviction in 1998 out of Ohio, a disorderly conduct in 2003, also a conviction out of Ohio, driving while license suspended, which is the basis of the one prior as filed in that case, in 2015, and also a possession of drug paraphernalia in 2015, with also withholds of a no valid driver's license in 2009 out of Brevard County, and also out of Brevard County, another petty theft, which was also a withhold of adjudication in 2013. The state would offer that Ms. DeRossett continued to ignore court-ordered conditions of her release twice, and due to her continued defiance, it resulted in the deputy being shot. In light of all these facts, the state requests that Mary DeRossett be sentenced to 1 year in jail.
Right. What says the defense?
Yes. Judge Gabriel Jacobs Kirstein for the defendant, Ms. DeRossett. I handled the first case that occurred in 2014. That was on November 25th, the alleged petty theft and possession of paraphernalia, and now, of course, the false name that the state has agreed to drop. My colleague will be handling the other two cases. As to the first case, first of all, I mean, it's pretty obvious it happened in November. It's 9 months before this incident occurred, and that's really why we're here. Our thoughts go out to the family, but at the end of the day, we would ask that the state consider, of course, following that and go ahead and giving her either withholds or adjudications and a credit time served, no probation on that.
Anything else for the defense?
Yes, Judge.
Thank you, Your Honor. As to the second case that we're here for, this would be the first solicitation and the driving while license suspended. I think it's important for Your Honor to understand a little bit clearer about how this whole interaction with Ms. DeRossett and the Brevard County Sheriff's Office even happened in this case that led to the July incident and then, of course, the tragic August incident. I think Mr. Tapa already acknowledged to you that deputies were looking on a website called Backpage. I think it's important to recognize that Ms. DeRossett, under the law, may not have even committed solicitation, which is what she's being charged with. As a matter of fact, she never once reached out to any of these officers offering services or anything of that sort. It was officers that contacted her through text messages, as the state said. Eventually, a meeting place was arranged, and this is on the July case, and Ms. DeRossett is now charged with driving while license suspended, though that is an activity that never would have happened had the deputies not asked her to meet them somewhere else. Not making excuses, Your Honor, but I think it's important to recognize that now Ms. DeRossett has what the state has agreed to on that particular charge, 49 days credit on a second-degree misdemeanor and the driving while license suspended. I think it's also important to recognize we're not talking about a violent offender here. As a matter of fact, as Mr. Jacobs acknowledged to you, from the November case to these new interactions, there was no police interaction at all. It wasn't until police were trying to sting Ms. DeRossett that she had any interaction. She wasn't committing crimes. She wasn't doing any of these things from that petty theft. Now, the priors that the state has read to you are all relatively petty. They're all misdemeanors. She doesn't have any felonies in her life. The amount of time she spent in jail as a result of this incident has rendered her scared. She's now got 49 days in on that case I just mentioned, 46 days since this August 21st case, more time than she's ever spent in jail by hundreds of times over. She is sort of still reeling from the entire thing and obviously wished this never happened. Certainly, the events that unfolded on August 20th and 21st are things that Ms. DeRossett would never have wished on anybody. Certainly not her intention. I think, as the state suggested, that it was her actions that caused this. I think that's absolutely debatable, which leads me to that third tragic case, which is why I think we're all here and what's brought this attention. The solicitation was conducted much like what I just mentioned. Again, not Ms. DeRossett trying to contact somebody. And I think it also should be, I think you should understand, her ad on Backpage doesn't advertise sexual services at all. So it wasn't until she was stung that any discussion like that even came up, and only then after the officers were asking her. As to the resisting, which is something that is really important to us at the defense, we believe that she's actually innocent of that charge, and I'll tell you why. When the officers approached that door, we have conflicting witness statements and testimony that isn't before you, Your Honor, but about what the officers were wearing. I'm sure you've seen some of the media coverage about this. But as to Ms. DeRossett and what she's charged with, there was an affidavit that Mr. Tapa just read from, and this goes directly to the resisting because that's why I couldn't stipulate a factual basis. This affidavit is dated, August 25th, I believe. Yes, sir. And this was an affidavit filed in her uncle's case, John DeRossett. This was an affidavit in support of the arrest of Mr. DeRossett. Now, the affidavit says that upon arriving to the residence, Agent Smith and Agent Roberts were deployed as backup for an undercover operation, and that Agent Peter Stead approached the front door. That's what Mr. Tapa just explained. I hesitate to go into what I'm about to go into, but it's important for my client and for you to understand when it comes to sentencing her. And I won't go into much detail because I don't think it's appropriate. But there are arrest affidavits on two officers in this case that that were written, the date on them when they were sworn to was September 15th, 2015.
Your Honor, I'm going to object to this. It's irrelevant to this.
All right, let's approach. All right, so objection is overruled. I'll allow it within the boundaries we discussed.
Thank you, Your Honor. As I was saying in the affidavit, it mentioned that Peter Stead was the one who approached the front door. That was the factual basis that was just laid by the state. In the PCAs dated September 15th, there are two of them that are dated the same day, written differently about different events, but absolutely they were turned over in discovery to us regarding this resisting issue. I think it's important to note that they completely contradict that contention that in fact it was Officer Stead that approached the front door that Ms. DeRossett allegedly resisted. As a matter of fact, it says upon arrival to the residence, it was Agent Smith who met with Ms. DeRossett at the front door, identified himself. In the second affidavit, also dated 9/15, it says that it was Agent Smith who met Ms. DeRossett. Now, these affidavits come out of the Brevard County Sheriff's Office. They're what the state, I would contend, they rely on these things when they make their filing decisions. I think it's really, really important, if not maybe critical, to understand for a resisting charge, one, that the person knew it was an officer. We're contesting that she didn't. Secondly, even the information coming out of the Brevard County Sheriff's Office is in direct conflict with itself. One affidavit says it was Officer Stead. Another affidavit says it was Officer Smith who made the initial contact, and yet another affidavit says it was Officer Smith. And under no circumstances, there's been no evidence that suggests that Officer Roberts was the person who ever approached that door. So I would ask that the court consider what I'm proffering here in this resisting issue, because it's important to go to my client's mental state and whether or not she even understood that they were officers at that critical initial moment. And on top of it, we're not even sure, at least BCSO isn't even sure, which officer it was that she was resisting. Now, I'd like to turn to Ms. DeRossett's original PCA herself on this case. Now, this is dated, the date of the offense, of course, was August 21st. This PCA was sworn to on also on August 21st. The closest thing we have in time, I would suggest, as it relates to Ms. DeRossett to this incident is what I'm looking at. And it says nothing at all about resisting. Not one thing. Not even a suggestion. That's 4 lines. There was a supplemental narrative, though. That was dated September 9th. In the narrative, which is longer, it's 4 pages long, it mentions absolutely nothing about the resisting. I think I'll go ahead and just read the part where they approach the door. This narrative goes into text messages, things like that, but then it says at approximately 2100 hours, agents Steed, Smith, and Roberts responded to the residence where she was taken into custody. I said in the beginning of all this that we've contended all along that Ms. DeRossett's not guilty of this offense, but that the only reason she's pleading to this is because her on a case where she had already bonded out, her bond was revoked. On your case initially, her bond was revoked on August 21st because of this. She was given no bond on this. Now, any normal situation where we're talking about a second-degree misdemeanor, which is what she was originally charged with by the BCSO, it would be unheard of for someone to be held on no bond, at least under the way that this county generally does things. It's near unconstitutional. But yet she's been there for 46 days on that charge. She's now got 48 days on the original one. And as per agreement with the state, 49 days on that middle one.
And it's my understanding that was done at the jail by whichever judge was at the jail.
It was her initial appearance.
Right.
And the state asked to revoke her bond on your case. I think their intention was to revoke her bond on the middle one. It just looks like that didn't happen, but nonetheless, that was the intention, so they've agreed to go ahead and acknowledge credit for that time.
And she hasn't had a bond hearing yet?
No, Your Honor.
Okay. All right.
So that's where we're at. She feels that this is in her best interest because she's been being held in jail. She feels pressured in some ways. But at the same time, as to the resisting, I think it's really important to consider these things, and that there is no mention of it in her arrest affidavit or in the supplemental narrative. Now, as I mentioned, that's where we're at with the time. On the case number 50731, 48 days, credit time served, 35073. The original sting solicitation, 49 days. And on this newest one, it's 46 days. What we're at, considering that this isn't a violent offender, this is a person that was caught up, certainly whatever the circumstances around this tragic night, it's certainly not something she intended. She's not a felon. She has been transported from Brevard County to Seminole County away from me without access, without even telling her counsel. For the last week and a half, she wasn't even allowed to have a phone to talk to me. This person is traumatized, as anyone, I think, any reasonable person would be after this sort of incident. But it certainly wasn't her intention. This was an operation conducted by the Brevard County Sheriff's Office, not something she went out to seek to happen. Now, those facts regarding her uncle, that's for a different day. That's not for today. But she never intended for anyone to be hurt. What we're asking for, given the, outside of all the media craziness, if this were just the regular cases, these are all misdemeanors. She's done a lot of time. What we're asking for is a credit time served on these cases. We understand the sensitive nature of the incident. And everyone on the defense and Mr. Rossett, wishes that didn't happen that way. If I may have a moment, Your Honor.
Right. And one thing I want to clear up is I want to make sure I have the correct credit time served, especially on the driving while license suspended case 35073.
Sir.
Because I'm not sure I have it correct on my...
Okay. It was 3 days.
Right.
My understanding was that the state intended on August 21st to revoke her bond on that one. It hadn't been done. However, she has been in for an additional 46 days because of August 21st. I did ask the state beforehand if they would be amenable to just agreeing, stipulating the 49 days is what it would be.
Okay, on that case.
49 days on that case, Your Honor.
All right, and the state in agreement?
Yeah, the state's in agreement, Your Honor.
With that?
Defects, I think there might be a discrepancy because it does state in the minutes of the initial appearance that Judge Majid stated that both cases were...
Okay, all right. And I'm showing on the case involving the resisting charge, 39028, that she has a total of 46 days credit.
That's what I have, Your Honor.
Correct. And 40, looks like a total of 48 on the paraphernalia case that was originally mine.
Yes, sir.
Okay, all right. Just want to make sure I have those correct. All right.
May I have one moment?
Yes, go ahead.
Nothing further.
Is there anything that your client wants to say before sentencing, or not? No. All right.
No, sir.
All right. Anything else for the state?
Just very briefly, Your Honor. For one defense had mentioned that possible constitutional issues with Ms. De'Rossett being held for this long. I just want to point to Chapter 903, 0471, that a court may revoke pretrial release and order pretrial detention if the court finds probable cause to believe the defendant committed a new crime while on pretrial release. That is what happened here. Also, just one other thing, the defense kept referring to this as a normal case or in regular circumstances, and there's no intention of Ms. De'Rossett. The state is not claiming that there was any intention, direct intention from Ms. De'Rossett. The state is saying that but for her actions, an officer would not be shot, and that is not a normal case.
I understand. And ma'am, how do you pronounce your last name? DeRossett. And is that the name that you go by, or do you go by Ellis? You go by Ellis? After considering all the aggravating and mitigating circumstances that were provided, I understand the state's position that but for Miss Ellis, also known as DeRossette's actions, the shooting would not have occurred. However, it wasn't a situation where there's any evidence that she could have anticipated that would have occurred or had expected that something like that could have occurred. So I think that's a mitigating factor as well. And I think that her uncle is responsible for whatever actions he's responsible for as well. But I think there is some additional penalty in regards to this because of the fact that, this solicitation or this prostitution charge occurred while another similar charge was already pending, while my case was already pending. So you had two other criminal cases already pending at the same time when this occurred. So despite that, you continued to with these actions. I'm going to start with the resisting case first, 2015 MM 39028. And why don't you go ahead and come on up. I recognize the defense argument that if it hadn't been for what occurred with the deputy being shot, we certainly wouldn't be here today with all the media and with the state requesting as much time as they're requesting, I'm sure, given the circumstances. So that's another factor that I'm considering. But what I think is appropriate under the circumstances is this. I'm going to start with count 2, the resisting charge. And frankly, I understand the arguments for and against that, but she has pled no contest to that. And frankly, because it's a first-degree misdemeanor, that's why I'm structuring the sentence in this manner. On the resisting charge on count 2, I'm going to adjudicate her guilty. I'm going to go ahead and sentence her to 180 days in the Brevard County Detention Center with credit time served of 46 days. So basically 6 months minus a month and a half, minus whatever credit the sheriff will give her. So she's probably looking, as a practical matter, at about 2.5 months to do after this in jail. All right, and then consecutive to that, on count 1 on the prostitution charge, I'm going to adjudicate her guilty. I'm going to place her on 6 months supervised probation. As a condition of probation, I'm going to order that she's to be tested for sexually transmissible diseases. She's to attend and complete an HIV awareness class. She's not to consume any alcohol or any illegal controlled substance. She's to submit to random testing for any such consumption as requested by her probation officer and pay for any such testing. And she's not to access any websites like Backpage.com or any similar website to advertise any services of any kind. And the probation will commence upon her being released from jail by the sheriff. She's also, and I'm not going to make this a condition of probation, but she's also to pay $354 cost investigation for the Brevard County Sheriff and pay court costs. And we'll cancel the October 27th court date that was previously set in Viera on that case. And I'll come back to actually, I think on the money, on all of the money, I'm going to order her to pay all those outstanding obligations within 18 months on everything. All right. And then let me go back to the first solicitation case, 2015 MM35073. On count 1 solicitation, I'll adjudicate her guilty, place her on 6 months supervised probation to run consecutive to or immediately following the first solicitation probation. So it's 6 months followed by 6 months probation. So that's a year probation. Same conditions. If they have not been completed, STD testing, HIV awareness, no alcohol consumption or controlled substance, illegal substance consumption, submit to random testing, pay for any such testing as requested by your probation officer. No access to Backpage.com or any other similar websites to offer any services of any kind. On the driving and on the driving while license suspended, I'll adjudicate her guilty, sentence her to 49 days in the Brevard County Detention Center with credit time served to 49 days. Order her to pay court costs, $684 cost of investigation for the Brevard County Sheriff, all to be paid within 18 months, along with any public defender assessments on these cases. And then on the last case, 2014 MM50731, on the paraphernalia charge, I'll adjudicate you guilty, place you on 6 months supervised probation, sentence you to 48 days, Brevard County Detention Center with credit time served to 48 days. This probation is run consecutive to all the other probation, so 6 months plus 6 months plus 6 months. So after you get out of jail, 18 months probation, no consumption of alcohol, any illegal controlled substance, random testing, pay for any such testing as requested by your probation officer. On the petty theft charge, I'll adjudicate you guilty, sentence you to 48 days, credit time served 48 days. I'll order you to pay $291.39 cost of investigation for the Titusville Police Department, court costs, pay everything within 18 months. I didn't hear anything with regard to any restitution on that case. Is the state aware of any?
No, Your Honor.
Okay.
And also, can we be clear on whether Ms. DeRossett is to serve in Brevard County?
You know, I didn't order her to be transported to Seminole. I usually leave all security arrangements up to the sheriff. If the sheriff thinks that he can safely provide housing for her here, that's up to him. If he thinks that she needs to be protected and serve it elsewhere, unless you all have some thoughts on that. I mean, do you have a preference?
We do, Your Honor. We do have a preference. It would be Brevard.
Okay.
She was transported to Seminole sort of without us knowing. It's far.
Is the state aware of any particular reason why she can't serve her sentence here?
No, but I would defer to Brevard County Sheriff's Office for to make those decisions.
Well, I don't think, I'm not sure whoever would have that answer is here now.
Right.
So I will go ahead and order that her sentence is to be served here in the Brevard County Jail unless I hear from the sheriff that there's some legitimate issue of security for Miss Ellis, and that she needs, at least for her own protection or for some other reason, to be transported somewhere else. Since no one else seems to be aware of that reason. Right, so if I do hear from the sheriff, I will quickly ask for everybody to gather back here. It may come as a surprise to the jail if she's being transported back there today, however. Does she need to go back to Seminole County and then be transported back to Brevard with any of her property or anything of that nature?
She doesn't have any property, Your Honor.
Okay.
You have it with you.
Okay.
So she could go to Brevard if that was,
All right.
you know.
All right. Well, tell you what. Before she's transported back, we can check with the jail and see. Just let them know. Give them a heads up that that's what I'm ordering, so that it doesn't come as a surprise when she checks in.
And Your Honor, there's no suggestion that you want her in solitary or anything like that.
No.
Right? Wherever she is.
But that's something I leave up to the sheriff.
Right.
if they determine that there's something that's necessary for security reasons, they make those determinations. I don't want to step on their toes in that regard. So I'm not ordering that. Is that something that she wants?
No, Your Honor.
Okay. So I'm not ordering that. I'll leave that up to the sheriff to decide using whatever criteria they normally use. So you might want to discuss that with the sheriff at the jail.
Yes, sir.
And clear those up. If there's an issue, let me know. I'll be happy to weigh in and address that.
Thank you.
Yes.
Judge, would you consider early term at 1 year upon completion of everything? If she were to come back in at that year point with only 6 months left on probation and everything pretty much done, would you consider doing that?
I'm not going to make that determination now.
Okay.
All right. I'm not ruling it out, but I'm not going to make that determination now. I think that Ms. Ellis needs to plan on serving the full period of probation. However, if under the circumstances you think that there's a legitimate reason for that at the time, I'll be happy to consider it. All right, and we'll go, and the state will have a chance to be heard as well. Madam Clerk, did you have any questions? With regard to the class, why don't we say within the first 5 months of her probation? All right. So the HIV awareness class is probably a 2-hour class. So within the first 5 months after you get out on probation. So, Ms. Ellis, do you understand the sentence? All right. I'm trying to balance everything here. It could be much worse for you. Could be better, but it could be much worse. I can't ignore the fact that as a result of your actions, a scenario was set up that a sheriff's deputy was almost killed, and that your husband and that your uncle is now in jail charged with attempted murder, and that these actions were taken while you already had 2 pending criminal cases. So I think this is a fair sentence, all in all. You have a right to appeal in 30 days. If you can't afford an attorney, I can appoint one to represent you. You'll need to be fingerprinted. Solicitation also and theft are charges that get progressively worse in the future if you continue to commit